5. I am for the petition
I am for
only.
the de facto.
My lord, dispute regarding the repayment of loan amount. In paragraph number 5, I clearly stated that the complainant and her associates run a loan business and they give loan after imposing huge interest. But here in this case, the petitioners already paid a colossal amount of money, about 4 lakhs. My lord, I have calculated right now, about 4 lakhs have been paid and no significant amount is lying due. But thereafter, what is the matter, my lord? On 6/2 of this month, 6th day of February, my lord, they came at our house, they assaulted us, for which, my lord, we made an indictment before the Constant Police Station, on which basis a case has been started. My lord, page number 12. Our case number is 78, dated 11/2/2025. Sensing the, my lord, gravity of the situation, my lord, they thereafter filed an indictment and this present case has been started. So loan amount, my lord, colossal amount has already been paid. I have got all the documents and thereafter, my lord, we have been assaulted. We made, my lord, first written complaint before the police station, on which basis a case has been started against them. Thereafter, my lord, after 2 days, they made this written complaint and accordingly the present case has been started. My lord, I am the wife and my lord husband.
Took money of rupees 10,65,000 and different persons also took money, my lord. Thereafter, she did not pay, my lord.
How many people money has been taken by the petitioner?
My lord, as per allegedly 5 to 6%.
5 to 6%.
Only one has lodged this complaint, my lord.
What is the total amount taken by him?
But here it is written, my lord.
No, that has not been assessed at that point.
Huh?
That has not been assessed at that.
Please give a report. Petitioner submits that she had taken personal loan from the de facto complainant and had repaid a portion. As she was unable to pay, as they were unable to repay the remainder, dispute cropped up. Case and counter case have been registered. They pray for anticipatory. Learned lawyer for state and de facto complainant submit. Petitioner runs a petitioner is the representative of a finance company. On the promise of giving high returns, she had taken loan not only from de facto complainant but other persons also. In light of this submission, state is directed to submit report with regard to the number of persons from whom petitioner had taken loan and the number of persons petitioner had taken money and the quantum of the said and the amount of the said money taken. Matter will appear 1 week hence. Petitioner shall not be arrested for 2 weeks or
Highly obliged. Highly obliged.
The counter case records be also produced. Give the number.
Yes, it is annexed. It is annexed.
Case record, you have got it?
My annexed.
Case and
It is annexed. It is.
Case diary.
So case diary case diary.
Case diary of the case registered by the petitioner shall also be produced.
Highly obliged. Highly obliged.
Officers of electricity department went to the land of agricultural land of the petitioner.
Nobody can enter your land.
Lordship,
Nobody.
they disconnected my connection.
You are the true lord of the English manor. Nobody can enter your house.
They disconnected.
Even officers, if they enter, they will come up, broken nose, broken hand.
On duty.
On
On
duty
duty, public
officers,
service,
they are
safety and security is
they are
there.
assaulted. Why? What is their fault? They entered your house for inspection.
Agricultural land.
Agricultural.
And you are
That is
hooking.
another big. You are a big farmer.
Lordship, entire amount has
does
been paid.
not. You touch a
Lordship, subject to my instruction, there
And
is
he is having
only
your offender.
hot altercation. No one
Hot
received any kind of
altercation.
injury.
1302 is pending. Trial is going on.
No one received any kind of injury. Only hot altercation.
Whatever it is.
Generalized body ache by altercation. All right. Petitioner submits that there was a altercation between the petitioner and the officers of the electricity company. He has repaid the outstanding dues. He prays for ancillary. Learned lawyer for the state submit. Petitioner had assaulted the officers of the electricity company who had come to disconnect the illegal pilferage of electricity. We have considered the materials on record. Allegation of assault is not injury report does not show injuries, on the officers. Full stop. Petitioner has already repaid the the bill, the final assessment bill raised for unmetered consumption. Under such circumstances, we are of the opinion custodial interrogation is not necessary and petitioner may be granted answer.
Great.
I am for the petition. But the allegation is that on the land of the complainant, towers were installed. He was induced to invest on various accounts. No, my charge sheet has been submitted.
It's on record.
Charge sheet has been submitted.
Petitioner is a member of a gang which carries on cyber fraud by inducing individuals to part with money on the false promise of setting up 5G towers. Prayer for pre-arrest bail of co-accused had been turned down. Custodial interrogation for unraveling the ramifications of the crime is necessary. Accordingly, we are not inclined to grant it.
And the necessary notifications will be issued by today only.
Please
The
do.
Lordship has directed all
Yes,
the
all the
police
any
stations to be
case, please local police stations to immediately
It- it-
inform the
it-
CID
It will
so
be
that
done
they
today
can aggregate these cases.
Oh.
Next,
Should I
So I am for the petition. So the allegation in the complaint is also the de facto complaint intended agreement with the petitioners to purchase a plot of land and paid certain amount. But your lordship dispute as was there after the land price was escalated. But your lordship, the petitioner did not pay the balance amount. Now it is admitted in the FIR the petitioner returns 3 lakhs rupees already.
Now he's not transferring the land, doing sell it.
Your lordship, petitioner are the student of the de facto complainant.
huh?
Petitioner are the student of the de facto
Are
complainant.
the
Your
students
lordship.
of the de facto?
Your lordship, and they took undue
Petitioner
advantage. Your lordship.
submit that the allegations at its height disclose breach of contractual obligation. He prays for ancillary bail on a lawyer for the state and de facto complaint oppose the prayer. We have considered the materials on record. Petitioner and the de facto complainant had entered into an agreement.
Your lordship continuously.
Petitioner had entered into an agreement with the de facto complainant had agreed to sell his land to the de facto complainant. He had taken an initial deposit. Subsequently, he refused to do so. Uncontroverted allegations at its height disclose breach of contractual obligations. Allegation of assault is not supported by medical evidence.
Your
Under
lordship,
such
they are
circumstances,
abscond from
we are
1.5 an hour.
Right.
Half an year, your lordship.
Prosecuting officer wants it to be confirmed. Next.
Well,
Yes.
Allegation of forgery. The petitioners tried to forge the engine number and chassis number of a particular car. That is the allegation.
The
finance was obtained.
vehicle has been seized.
No,
Then
no vehicle has not been seized.
we have considered the materials on record. Petitioner and co-accused changed the chassis number and engine number of a vehicle which has been let out by the de facto complainant company on a hire purchase agreement. Vehicle has not yet been recovered. Custodial interrogation for recovery of the vehicle is necessary for progress of investigation. Accordingly, we are not inclined to grant answer. Next. Very good. No days of the Yes, how long you are, when was the marriage?
Lordship,
2020.
Lordship, all allegation against husband, Lordship, and husband granted bail, Lordship, after 1 month. She commits suicide, Lordship.
Who are you?
Mother-in-law and mother-in-law.
Petitioners are the parent-in-law of the victim lady. It is contended that they have been falsely implicated. They pray for anticipatory and a lawyer for the state opposed the prayer. We have considered the materials on record. Petitioner victim had married the son of the petitioners in 2022. Allegations are primarily allegations against the petitioners, that is the parents-in-law general and omnibus. She committed suicide. A victim committed suicide. Custodial interrogation for principal accused, that is the husband, is on regular bail. Custodial interrogation for progress of investigation is not necessary. Accordingly, we are inclined to grant answer. Next.
I for the petitioner, co-accused statement, nothing recovered from the petitioner, Lordship. Same footing, one co-accused enlarged on bail, Lordship. Statutory bail.
Lord, the principal accused has been granted statutory bail.
Yes, Lordship.
The allegation is that that person was supposed.
Investigation complete.
No, it is.
No, Lordship.
Let her surrender. We have considered the materials on record. Petitioner is involved in trafficking narcotics across international border. Good stuff. It is alleged he ran away from the spot. During investigation, he could not be, he evaded investigation and could not be interrogated. Custodial interrogation, in view of the nature of the crime, we are of the opinion custodial interrogation shall yield further evidence and may lead to recoveries, and accordingly we are not inclined to grant answer. Next.
Lordship, I am appearing for the petitioner. May I please your Lordships? Allegations are under section 3032.
I just received CD now. Not today, because I received CD just now.
Lordship, allegations are under section 3032, 317.2, 317.4, 317.5, 221 of the BNS, Lordship. Principal accused from whose
Where is
possession.
your case diary?
Yeah, case I have, but
Huh?
I just received now, sir. I just received now. My lord.
Just received it.
He will need a lawyer to argue. What is your name?
MDA जा सकता है.
What?
MDA जा सकता है.
Are you practicing?
3 years.
3 years. Where?
In Calcutta High Court.
Calcutta?
Yes.
Show me how many orders you had appeared.
Just now I.
Huh?
Later on I give you mine.
How many cases have you argued? Show us certified copies of orders. Yes, what is there?
Lordship, the principal accused from whose possession that stolen article was recovered and who was
What is
present.
the FIR? What is the allegation in the FIR?
Allegation is the principal accused.
FIR. Let us see.
Lordship, principal accused have been enlarged on bail, Lordship, by the learned court bill on 24th of December 2024, Lordship. And therefore, charge sheet has been submitted on 31st of December 2024, Lordship. And nothing was recovered from my house, Lordship. Nothing was recovered. General and omnibus allegation, Lordship.
Remove the accusation, Vivek Mondal. You are Ganapati Mondal.
Yes, Lordship. My name has been transferred from the statement of the co-accused, Lordship. I was not present at the place of occurrence. Is it fair?
Yes, yes.
Yes, they found him. Nothing was recovered, Lordship, at my place.
Ganpati Mandal.
Lordship, any stringent condition?
No. Petitioner submit, no stolen property was recovered from his possession. Co-accused has been granted regular, co-accused,
Lordship, principal accused.
principal accused, there is no principal. Principal accused, Biplab Mondal.
Vivek Mondal, Lordship.
Vivek Mondal has been granted regular bail. He prays for anticipatory bail. Learned lawyer opposes the prayer. We have considered the materials on record. Vivek Mondal and two others were illegally smuggling mobile phones across international border. BSF personnel chased them and arrested Vivek. Full stop. Others ran away. On interrogation, complicity of the petitioner as one of the smugglers has transpired. In light of the nature of crime, we are of the opinion custodial interrogation of petitioner is necessary for the purpose of unraveling the ramifications of the crime and for further recoveries. Rejected. Next. Yes, certainly this. Yes,
My lord,
nature of injury.
case and counter case.
Fracture.
Our case is earlier. Both sides sustained injury,
Fracture.
and 7% has already been granted anticipatory bail in connection with this case.
But you are the principal.
Your lordship kindly sees.
There are specific allegations. Lordship,
I-
there is a fracture
I
in the
also-
dental area and one of the
I
arms.
also sustained injury. That injury report is with the petitioner. I have annexed, my lord. Page 7 and 8. Lordship kindly sees. In both sides, somebody sustained injuries.
Page
There's a family dispute, and our case is earlier.
Lordship, page 33 is the medical. There is a fracture in the dental area and in the right arm. There were other also present there who are also injured. Disputes over property.
So-
They came
Yes.
to the house and assaulted them.
Ariful and others all stand on the same footing.
No, your lordship.
Why?
Sariful and Ekramul, there are specific allegations
Allegation against them. They are
against them.
specifically
Lordship
named.
kindly peruses the FIR.
FIR says no number বিবা দিয়ে হাসুয়া দিয়ে পা পায়
So, Lordship,
Non-number is the second petitioner, lordship.
huh?
Non-number is the second petitioner.
Second petitioner will reject. And
Lordship, page 13 is the 161 in which.
where is the first petitioner?
Lordship kindly sees the FIR.
Yes.
Yes, we are.
What are they?
Read out the first petitioner's role.
Lordship,
line.
9th line.
Can't you read out?
আঘাত করে এবং তাদের মাটিতে ফেলে গলা টিপে ধরে 1 নম্বর বিবাদী আর বাকি বিবাদীরা মৃত্যুকে নিশ্চিত করতে তাদের বুকের ওপর চেপে বসে।
এক নম্বর
Allegations
বিবাদী
আছে?
we will give.
Nine.
That petitioner number 2 will reject. Petitioner, we have petitioner submit that there was a free fight. Case counter case was registered. Co-accused have been granted anticipatory bail. He prays for similar relief. They pray for similar relief. Learned lawyer for the state and de facto complaint oppose the prayer. We have considered the materials on record, including allegations in the FIR and statements of witnesses. Full stop. Specific overt act, a specific allegation of assaulting one of the victims with Hesua is leveled against petitioner number 2. Hence, we are not inclined to grant anticipatory bail. The ocular statement is supported by medical evidence. Any incised wound is found. What sort of wound?
No.
Property dispute, Your Lordship.
Oh, wound.
Wound. Fracture injury. There were 2 fracture injuries.
Yeshua, how fracture?
So we have page 33 is the medical in which there is a dental injury, dental fracture, and one right arm.
None of them are Yeshua. We have considered against in respect of petition number 1, it is alleged that we had encouraged co-accused and tried to throttle one of the victims. Injury report shows fracture of arm. Injury report does not disclose any injury on the throat, nor does it indicate any incised wound. It discloses a fracture which is improbable, which could not have been caused by a Yeshua. Accordingly, we are co-accused have been granted anticipatory bail. Accordingly, one of the petitioners had also suffered injuries in the fight. Accordingly, we are inclined to grant anticipatory. Not them. The ones who were granted it with something which causes fracture.
Me, His Lordship, and for the petitioner, husband will.
Yes.
A petitioner's mother was attacked by his wife. He only tried to pacify them. Wife
All
failed.
right. We have considered the materials on record. There was a domestic quarrel between family members.
10 years marriage.
Injury does not appear to be grievous or life-threatening. Accordingly, we are inclined to grant answer.
I'm high low.
Now, the non-billable section are 109 and 303 subsection 2 of the BNSS. That is 379 read with 2527 Arms Act. They are the co-villagers. In the paragraph 5, I have stated the real incident which has been colored in a different way in this case. On the date of Urus, this petitioner was supposed to give some donation in the way of.
No, my lord.
Kind of.
My lord, kindly see this 164 statement.
Kindly see the paragraph 5, my lord.
Extortionists.
No, my lord, kindly see paragraph 5 for once.
Who had demanded money from
not money, my lord.
Money, my lord. That is the
money from the de facto complainant's husband. On refusal, he was physically assaulted.
Yes,
in view of the daring nature of act committed by the petitioners, we are not inclined to grant answer. Unish. Next.
Lordship, I am for the petitioner. There is a long-standing dispute between the parties, civil dispute. Both parties received injury, both parties lodged complaints. I have annexed the complaint lodged. Lordship, now they have amicably settled the dispute between them.
Where petitioner submit that there was a free fight between two groups, case and counter case. Both parties suffered injuries. They have amicably resolved their dispute. We have considered, they pray for anticipatory bail. We have considered, a lawyer produces the case diary. We have considered the materials on record. We have also examined the injury report. Injuries do not appear to be grievous or life-threatening. Parties incident occurred in the course of on the spur of the moment, and parties have amicably resolved their dispute. Accordingly, we are inclined to grant it.
Great.
Next.
My lord, no motor FIR lost to that effect. My lord, 2% was apprehended with my lord, fake lottery.
What?
Fake lottery.
Fake lottery ticket.
1,000 pieces of
My
fake
lord,
lottery.
that is from the person, my lord, who were apprehended. They were subsequently granted bail. My lord, thereafter my name transfer.
297?
68 for 70.
460, 460.
That is 330.
338.
338.
460.
338 is 467.
467. 468, my lord.
297. You don't see the cost title.
We just received it, my lord. Right.
Oh, you just received the cost title now. Then you receive the FIR case diary now.
My lord, we have 294A,
94A.
420, 467.
Ah, 298.
294.
Selling lottery ticket.
Yes, that is
That's a bailable offense.
And section 7.
We have considered the materials on record. Alleged forged lottery tickets have already been seized. Custodial interrogation for progress of investigation is not necessary. May be granted it. Police should not, the lottery, the persons who purchase, they should take custody.
My lord, he is the supplier and the others have been granted statutory bail
Allowed.
because the report has
Great.
not been.
Cheating people by selling forged lottery tickets. Next.
Lord, I'm for the petitioner. Lord, although allegation 302, but I am claiming parity, my lord. Page 16 is
The only one thing is that, my lord, absconding, my lord.
No, no,
Otherwise,
no.
my lord, parity.
Petitioner submit co-accused.
16, page 16, my lord. Filsek is the principal accused.
Co-accused have been granted pre-arrest bail by the Honorable Apex Court. Petitioner stands on the same footing. Accordingly, we are inclined to grant anticipatory bail. So one I have given. Imtiaz Sheikh was given by this bench.
2 by Appeals Court, 2 by High Court. And
We have
2 by
been one.
My lord.
They stand on the
My
footing.
lord. 164 all are named.
They stand on the footing who have been granted anticipatory bail. Allowed. They are not the principal accused.
No, they were in the group.
Petitioners are not the principal accused. Co-accused similarly circumstanced with petitioner have been granted anticipatory bail by this court as well as the Honorable Apex Court. Accordingly, we are in. Next.
My lord, 41, this case, my lord, is very peculiar in nature, my lord. Why?
My lord, this case is some peculiar in some nature, my lord. Why I'm telling, my lord? My lord, in one Rajkumar Singh was apprehended by the BSF personnel with 49 bottle of fentanyl. Thereafter, he took to the, my lord, local police station. In local police station, my lord, he has made a statement that the consignment was procured from the present petitioner and he was assigned to deliver to one Guljar. Accordingly, against 3 persons, Rajkumar, Habibul and Guljar, FIR was lodged. Subsequently, my lord, charge sheet filed, deleting the name of Guljar, the 2 person against 2 person, the charge sheet filed. Then, my lord, warrant of arrest against was issued against the present petitioner. Then, my lord, kindly come to page 29. There is a order of proclamation of attachment, my lord. Why I am, my lord, telling you, your lordship. Then, my lord, on one day, my lord, the issue of attachment was issued. Then, my lord, suddenly, thereafter, no report come. Without splitting up the record, which you are traveling subject to lordship kind sanction, the charge was framed against the Rajkumar. My lord, thereafter, the order sheet is entirely silent against me, my lord. Subsequently, the person Rajkumar was my lord, enlarged on bail. My lord, 3 witnesses has already been, my lord, examined. In this situation, my lord, whether this proclamation, my lord,
Forget about proclamation. We don't ignore proclamation.
that's true, my lord. But
fact that you were absconding is good enough for us.
For 2 years, 6 months.
Correct. It's good enough for us.
That is the situation, my lord. My lord, submitting before.
We are rejecting your application.
That
proclamation is irrelevant.
Well, witness action has already been started. 1 out of 7 witnesses partly examined.
That is wonderful. Have you declared him as a proclaimed offender?
Till date, my lord, it's true that no execution report has come.
Yes. So if he is not declared as a proclaimed offender, then the witness action is invalid so far as he is concerned. You have to again re-examine the witnesses. Petitioner submit the proclamation. Petitioner submit no narcotics was recovered from his possession. He has been falsely implicated. He was unaware of the institution of the proceeding. He prays for anticipatory bail. Learned lawyer for the state opposes the prayer. He contends petitioner had absconded. Prayer for declaring him proclaimed offender was made and 1 witness has been examined. We have considered the materials on record. Petitioner and one co-accused was apprehended. A co-accused who was apprehended?
Rajkumar, my lord, he has granted bail.
One Rajkumar was apprehended by BSF personnel with fentanyl syrup. His associates fled away. It is called
No, my lord, subject to lordship concern. This is not a FIR. They associate. On statement, he said the consignment was procured from me to deliver one.
No, there was a scooty. In the scooty, there were Habibul was there.
No, that's my lord. I have subject to lordship concern.
Lord, page 10 is the statement of these accused. My lord, this Rajkumar Singh, who was already enlarged on bail. Lord, he said he is the supplier. This petition is the supplier.
One Rajkumar was apprehended with fentanyl syrup. While traveling on a scooty. On his statement, complicity of petitioner transpired. Petitioner was not available during interrogation. He had absconded for 2.5 years. Trial has commenced against a prayer for proclamation was filed against the petitioner. Trial has commenced against Rajkumar. In light of the nature of crime and the petitioner's abscondence, we are not inclined to grant answer.
Grateful, my lord.
My lord, petitioner is an aged lady. The principal accused is in custody. The petitioner was initially not named in the FIR. Subsequently, in charge sheet, my name transferred. And I kindly says, my lord, what is my
victim was mentally challenged person. This is a statement of the eyewitness.
Consider the materials on record.
Principal accused is in custody.
Though victim is mentally challenged,
90%.
The petitioner is not the principal accused. Principal accused is in custody. Keeping in mind the extent of complicity of the petitioner in the crime, we are inclined to grant that.
Grateful, man. Good.
Next,
Well, section 20 and 29 of the NDPS Act, no recovery from the possession of the petitioner, page 17, second paragraph,
yes,
and page 30, my lord.
we have considered the materials on record.
Well,
the charge sheet has already been submitted against 3. After
against 2.
I have gone through the case diary. What I found, there is no CDS, no money trail. Only the co-accused statement. One Elias first was arrested. If your lordship kindly consider the statement of
Have you paid for further investigation?
My lord, no, my lord. In the charge sheet, I couldn't get any reflection from it.
What is recovered?
My lord, 235.150 kg of ganja, page 17. And my lord, one thing, my lord, the owner of the vehicle, my lord, discharged. Kindly come to page 30. Kindly come page 30, my lord.
Right.
And I, my lord, page.
We are not we are not looking into the owner's role.
No, my lord. But against me, nothing.
We are not going to give you answer. 235 kgs of gaja being transported. We will direct further investigation to be done.
Deeply.
235 kgs of gacha was being transported in a vehicle. Police apprehended the vehicle and arrested co-accused
Elias
Mondol. Gaja was seized, during investigation. Complicity of petitioner transpired. Petitioner was not available during had absconded and was not available during investigation. In view of the nature of the crime,
the search was conducted at my house. Your list is there, my.
So you house is you.
No, my lord.
Are you the house?
I will, my lord. My lord, your lordship passed the order. I will, my lord.
We want your arrest.
I will meet with the IOM.
Yes, you will meet in his custody. In view of the nature of crime and the fact that the petitioner had evaded investigation and custodial interrogation, we are of the opinion this is not a fit case to grant and suit report. As well as custodial interrogation.
Lord, I'm appearing on behalf of the petitioner. My lord, a 63-year-old mother-in-law is before your lordship. The husband has been granted bail.
How many years after marriage incident?
The incident occurred within 3 years. But the husband is on bail. Lordship kindly sees one finding of this honorable court. It's the husband who took the deceased to the hospital. We tried to save the deceased.
Right.
The death was due to poisoning.
Submit that there was a matrimonial dispute and victim committed suicide in an impulsive manner. Husband tried to save the victim. Petitioner is the mother-in-law. She prays for anticipatory bail. When a lawyer for the state opposed the prayer, we have considered the materials on record. Deceased had married Krishnendu Jana, the husband, 3 years ago. It is alleged that the husband and in-laws subjected her to torture over demands of dowry. But when victim committed suicide, husband tried to save her and took her to hospital. Allegation, he has been enlarged on regular bail. Allegations against the petitioner are general and omnibus.
Only one thing, my lord, in post-mortem report, it is says, my lord, that death was probably due to effects of, my lord, the poisoning. But, my lord, the FSL report says, my lord, no poison was detected. Thereafter, my lord, the supplementary charge sheet, my lord, 306 was, my lord.
The custody investigation is complete. Accordingly, we are inclined to.
Great. My lord, may I take back the copy of the order?
Next.
Order copy.
বেলের অর্ডারে গ্রেটফুল
399, 402 statement of co-accused charge sheet
We have
submitted.
considered the materials on record. No incriminating article was recovered from petitioner. Investigation is complete. Accordingly, we are glad to grant that. Next. Pradeep is a good boy.
Milord, on the basis of an source information, Milord, one Saddam Hussein was arrested. From his possession, Milord, the ammunition was recovered. Now the police had submitted charge sheet on Milord 29th April 2024.
The nature,
Absconding for more than 2 years, 3 months.
what is the nature of articles recovered?
Lordship, there was improvised firearms, single barrel,
How many?
71 pieces of ammunition and 12 pieces of ammunition
We have considered the materials on record.
from the house.
Large volume of illegal arms and ammunitions were recovered from petitioner, from co-accused. Petitioner's name transpired during investigation. He absconded and avoided custodial interrogation. Custodial interrogation would have revealed further evidence, including recovery of other illicit arms. Hence, we are not inclined to grant and suit. The petitioner had absconded for 3 years.
Grateful, Lordship.
Goat enter into
Goat entered.
goat enter into the cultivation land of the accused
Goat
number one.
entered cultivation land and you murdered man.
Physically assaulted but by the.
Then why didn't you attack the goat
For the skull.
instead of person? Huh?
Altercation took place the wife and mother of the petitioner number 1 and
7 stitches.
2% injured.
Then
both man 1 and 2.
who assaulted?
My lord, both, my lord. Both. Petitioner number 1 assaulted the de facto complainant and petitioner number 2 assaulted the husband of the de facto complainant.
We have considered the materials on record. Petitioner has assaulted the de facto complainant as her husband. They suffered sharp cutting injuries on the head. In light of the nature of the injury on a vital part of body, we are not inclined to grant that.
My lord, 318 fourth. 316 2, 61 2 of the BNS Act. My lord, in 2019, my lord, it has been said that he gave me the company gave the loan to this petitioner's partnership firm of 20 lakh rupees.
316 is 406.
420, 406, 120B.
318 is 406.
318 4 is 420. And my lord, 360, 16 2 is 406.
And 303 is 379.
379. My lord, 420 and 406, my lord, has been given together. And my lord, it cannot, subject to lordship's correction, it cannot
That
go.
would be at the time of conviction.
My lord, after Delhi Race judgment, my lord, after the Justice Padriwal's judgment, my lord, it has been said, just subject to lordship's correction, my lord, 420 and 406 cannot go together.
You're absolutely right. But in the FIR, facts are not clear.
My lord, in the FIR, in this case, my lord, it has been said that in 2019, he gave a loan of 20 lakh.
Alright.
Thereafter, I gave him checks, those got bounced. My lord, instead of filing 138 of the NI Act, my lord, filed this.
What is the quantity?
My lord, 20 lakh of rupees he gave in 2019 for me to keep fish in his cold storage. I am a partner of my partnership firm. My lord, thereafter, I said that I will repay the amount. My lord, it has been
Amount of
money.
20
lakh.
20.
6 years back.
All right. Petitioner submit.
My lord, I am beg to appear on behalf of de facto complaint. My lord, on 8/8/2024, again, my lord, he has given my lord, another check.
Present it, start 130.
No, my lord, account block.
So what?
Account block, my lord, I have
Start
spreadsheet, my lord,
140,
account block.
138.
The amount, my lord,
Start
time
138.
part, my lord, it is time.
Start to time, but who's
My lord, it was as per his instruction, my lord, I did
who
not.
asked you not to prosecute?
My lord, 420, that is.
Who asked you not to prosecute? Petitioner submits. There was a petitioner submits. There was a commercial transaction between the petitioners and the de facto complainant in 2020. He has made part payment. Subsequently,
No part payment. No part payment.
In 2020, checks issued by him were allegedly dishonored. Instead of instituting proceeding under 138 of NI Act, instead criminal case has been registered. He prays for anticipatory bail. Run a lawyer for the state and de facto complaint submit. Petitioner had dishonestly induced him to keep fish in the godown. Thereafter, he misappropriated the said consignment when
My lord, the accused person have taken a loan from the de facto complainant of 20 lakh and promised him to keep 10.5 ton of fish in his cold store. That has not been kept, my lord. Thereafter, money has not been
petitioner had taken a sum of rupees 20 lakhs as consideration for 20 lakhs and assured that he would hand over 10.5 tons of fish. He failed to do so. Subsequently, checks issued by him were on a defunct account. This discloses his dishonest intention. Full stop. We have considered the materials on record. In 2020, de facto complainant had given a loan of rupees 20, had paid a sum of rupees 20 lakhs.
19.
Had paid a sum of rupees 20 lakhs to the petitioner. In return, petitioner assured them he would hand over 10.5 tons of fish. This was not done. This was not done. Subsequently, checks issued by the petitioner were dishonored. The first part of the transaction discloses breach of contractual obligation between parties. The subsequent transaction resulting in dishonor of checks would may yield to prosecution under 138 of the Negotiable Instruments Act. But it is difficult, full stop, but it is difficult to comprehend that dishonor of checks per se would attract dishonest intention in the mind of the petitioner from the initiation of the transaction in 2019. Accordingly, we are inclined to grant ancillary bail subject to condition, meet investigating officer once in a week.
I'm grateful.
Next.
My lord, I am for the appellant led by Mr. Ganguly, my lord. My lord, your lordships had the occasion to hear this matter on 2 occasions before, my lord.
Yes, tell us.
My lord, we prepared 2 short notes, written notes of argument, my lord. If I may just hand it over. My lord, the inception of this case is the extrajudicial confession of a minor co-accused person, my lord, Bablu Yadav. My lord, as far as the evidence goes, his extrajudicial confession was heard by PWs 1 to 7 and PW 9. But my lord, none of the witnesses state that the other PWs were present at that point of time when Bablu Yadav walked into a club called Jubok Shongo and made his extrajudicial confession. That apart, my lord, this extrajudicial confession is 2 years later from the alleged date of incident. My lord, why after 2 years and what is the familiarity of Bablu Yadav with these PWs is that is not there in the evidence, that why all of a sudden he came along and made this confession before them. That, my lord, creates certain doubts regarding the extrajudicial confession. Further, my lord, there is the evidence of PW 13, who is the eyewitness, who has stated that the appellant, under the direction of the appellant, he and the others had committed the murder of the deceased. And my lord, thereafter, the body was disposed of. This evidence is also, my lord, 2 years from the date of incident. For 2 years, the son of the deceased does not reveal this information anywhere. Even after the exhumation of the bones, my lord, 2 months later, he comes forward. Such delay is also not explained anywhere. And my lord, there is seizure apart from the exhumation of the bones. The other way that it is being identified that it is purported bones of the deceased, my lord, is the seizure of certain clothing apparels. But my lord will kindly peruse the exhibit 4, that is the seizure list. My lord, the seizure is not from the hole from where the bones were exhumed, but in the court, but lying around in the courtyard. And my lord, the inquest report of the magistrate as well as the inquest report of the investigating officer, both of them, my lord, reveal that apart from the bones, nothing was seized. The seizure of the clothes is belated. And also not from the location, exact location from where the bones were exhumed. My lord, the DNA examination is not conclusive as the bones were too disintegrated. Therefore, my lord, there is no conclusive proof on record to show that these bones were indeed of the deceased and not of anyone else. My lord, I am in custody for 10 years, 6 months.
You're not arguing a bail application, so you would
my
be
lord.
kind enough to come to the FIR.
My lord, may I start?
Who stopped you? I thought that you
No, my lord.
started.
May I place the evidence, my lord?
Who stopped you?
I'm sorry, my lord. That the FIR is written complaint is page 4 of the 5 of the paper book, my lord. It is by one Gopal Dash, my lord. He is PW 1. My lord, he has stated that my name is this.
Pandey, not Gopal Das.
No, my lord will. My lord, I'm sorry. That is the 195A FIR against the co-accused, the acquitted co-accused Devendra Dwivedi. My lord, page 2, my lord. I apologize, my lord. Page 2 of the paper book. Pandey so and so do hereby like to state that myself and other local people came to know from one Bablu Yadav that he, under the leadership of Gyan Sagar Sharma, that is the appellant, killed one Madan Roy since 2 years back by firing bullet on him, and after that they, Gyan Sagar Sharma, Bablu Yadav, Ranjit Sharma, Shabitri Roy, and Devendranath Dwivedi and others cut the body of Madan Roy into pieces and kept it in bags and placed it under the ground near the house of Gyan Sagar Sharma, situated at Rania Aurobindo Nagar. My lord, out of here, Bablu Yadav is a minor. Ranjit Sharma is also a minor. My lord, both of them were thereafter sent to the Juvenile Justice Board for their separate trial. My lord, I do not have instructions as to the fate of their trial. My lord, Debendranath Dwivedi was acquitted by the Learned Trial Court. And my lord, Shabitri Roy, she has been convicted under section 201 and sentenced to undergo 5 years of imprisonment. Actually, there is an illicit relationship between Gyan Sagar Sharma and Shabitri Roy since 2.5 years back. Suddenly, since 2 years back, Madan Roy has been found missing and cannot be traced anywhere. From then onwards, I have a doubt over the sudden disappearance of Madan Roy. Later on the basis of the statement of Bablu Yadav made before us, I am confirmed that Gyan Sagar Sharma, Bablu Yadav, Ranjit Sharma, Shabitri Roy, and Debendranath Dwivedi, alias Dubey, and others placed his body under the ground for disappearance of evidence. Today, on 9 June 2014 morning, in presence of myself, other local people, and learned executive magistrate, Shri Orumoy Bhattacharya, police personnel of Sonarpur police station recovered the skeleton bones, pant and shoe, which I and the other local people identified as of said missing person Madan Roy, beneath the ground situated near the house of Gyan Sagar Sharma of Rania. I therefore pray that necessary legal action may be taken. My lord, page 5 is the investigation report of the investigating officer. My lord, here will lordship will kindly see the cause of death not known. That is the point number 1. Name of the deceased claimed to be of Madan Roy. Description skeleton, but my lord, it is only 137 bones were recovered. The entire skeleton was not recovered. And my lord, on the next page, opinion, Gyan Sagar Sharma had murdered deceased on gunshot and buried him underground at the land situated by the side of his house about 2 years ago due to his illicit relationship with the wife of the deceased. Viewing of the surrounding in their totality, my lord, point number 9, with the dead body lying there, articles such as rope, weapon, ammunition, chemicals, file, etc. as per inquest. Well, this inquest report does not show that there was recovery of any wearing apparels of the deceased, as we will find in Exhibit 4. Next, page 6 is the magisterial inquest. Aishri Orumai Bhattacharya held inquest over the dead body of one claimed to be of Madan Roy of so and so, who was residing at the time of his or her death at village so and so. The dead body skeleton was examined at the courtyard of one Sri Gyansagar Sharma on 9 June 2014 between 3 p.m. and 3:30 p.m. on identification of the body as claimed by the investigating officer of the case. My lord, then there is the description of the corpse, but that is all, my lord, not there because it is only bones. My lord, on the next page, point C, general observations. As per order of SDO Baruipur, Vide memo number 42 dated 9 June 2014 and Shonarpur Police Station General Diary entry number 918 dated 8 June 2014, I, Orumai Bhattacharya, performed magisterial duty of disinterring a dead body claimed to be of one Madan Roy. My lord, this Shonarpur Police Station General Diary, there was an intimation sent to the police station on the 8th of June 2014 by an unknown caller that Bablu Yadav had purportedly made an extrajudicial confession that the bones of Madan Roy is in that so and so place. The caller had never revealed his name. No investigation was also done to the effect that where the call came from and what the CDR of or what the nature of the call was. My lord, thereafter some of the witnesses have stated that Bablu Yadav made the extrajudicial confession on the 9th of June, which is, my lord, a day later. But on the 9th of June, already the exhumation of the bones was in progress. So, my lord, in those circumstances, perhaps the first point of information is the general diary entry of 8th of June 2014. The process has been started at around 10:30 a.m. manually, but at around 2:30 p.m., one JCP has been used for the search of the body at around 3 p.m. and some disintegrated bones were found in 2 bags used for carrying of cement at the courtyard of one Gyansagar Sharma. During the process of inquest at that place, only 137 bones including disintegrated parts were found, including the skull, lower jaw, ribs, and other human bones. Apparent cause of death may be ascertained after postmortem examination. My lord, the next page is the rough sketch map of the place of occurrence. My lord, lordship will kindly see that as per the reference prepared by the investigating officer, my lord, the place of occurrence is actually the land of Devendranath Dwivedi. My lord, a deed of sale to that effect, also in the name of the wife of Devendranath Dwivedi, was seized by the investigating officer. My lord, the land is bound by a boundary wall. My lord, the house of the appellant is marked as GS on the left. My lord, there's a purported factory of the appellant just towards the bottom of it, which is FG. But my lord, no document to that effect that the factory of the appellant was existing there was seized and placed on record. That apart, my lord, there were other witnesses. For instance, the land of LS, which is Shukhenpal, my lord, he was not examined as a witness. That of LG, my lord, land of Gunodhar, alias 1 Guno, my lord, he was not examined as a witness. And RJ, that is towards the left, my lord, house of Ramkumar Jha. My lord, he was also not, my lord, very vital witnesses who were staying around the place of occurrence were not examined, and Devendranath Dwivedi has been subsequently acquitted. Then, lordship, the post-mortem report. Apart from one opinion that there is nothing to suggest that the victim suffered natural death, but my lord, the sword cuts both ways. There is also nothing to suggest that the victim suffered an unnatural death is also there. My lord, page 10, the deposition of PW1. I have received the summons to witness. On 9th June 2014, skeleton of Madan Roy was recovered near house of Gyansagar Sharma, which was kept in 2 plastic bags near house of Gyansagar Sharma, which was kept in 2 plastic bags and buried in earth After digging the earth, but my lord will kindly recall the magistrate had recorded in his inquest that the bones were recovered from cement bags, which are gunny bags. But here the PW1 states that the bones were recovered from 2 plastic bags buried in earth. After digging the earth in presence of magistrate and police personnel of Shonarpur police station and local people, including myself. At about 10 or 11 a.m., Bablu Yadav disclosed before me that he, along with Gyansagar Sharma, Ranjit Sharma, Shabitri Ray, Devendranath Dwivedi committed murder of Madan Ray, and dead body was cut into pieces and buried. At the time of digging, pant, shirt, and one shoe of Madan Roy were also recovered from that place. Gyan Sagar Sharma, Debendranath Dwivedi, and Shabitri Roy are present in court. I lodged complaint at Shonarpur police station. The complaint was written by my brother Vikram Pandey. My lord, Vikram Pandey is PW10. Vikram Pandey read over the contents thereof to me, and thereafter I put signature on the FIR. The FIR was written at the place where from the skeleton was exhumed. Vikram Pandey also put signature on the FIR as scribe. Thereafter, next para. This is the shoe of Madan Roy, which was recovered by the police. Let the shoe, one piece, be marked as Mat Exhibit 1. I had seen Madan Ray while wearing this shoe. This is mud-stained black pant, which was recovered by police in my presence, marked as Mat Exhibit 2. These are the plastic bags in which the body parts of Madan Ray were recovered by the police, marked as Mat Exhibit 3. These are the 2 cutteries by which the body of Madan Roy was cut into pieces. My lord, this witness was never an eyewitness. He perhaps could not have identified the cutteries to be the offending weapon which were used to chop up the body of Madan Ray. Executive magistrate held inquest in my presence, and I signed as witness on the inquest report. Bablu Yadav also disclosed before me that Gyansagar Sharma about 2 years ago fired Madan Roy by gun as he had illicit relationship with his wife, Shabitri Ray. The skeleton of Madan Ray was exhumed from the land of Devendranath Dwivedi situated adjacent to the house of Gyansagar Sharma. A whistle with black string and a key were also recovered on digging earth. This is the whistle with string which were recovered by police marked as Mat Exhibit 4. This is the key which was recovered by police marked as Mat Exhibit 5. Binod Singh, PW7. Gopal Dash, PW2. Bikram Pandey, PW10. Manik Shapu is PW12. Shubhendru Chakraborty not examined. Upendra Singh not examined. Shivji Tiwari not examined. Bholanath Mondol not examined. PW3 and Debendranath Dwivedi were present where the skeleton was recovered by police in presence of magistrate. The cross, your lordships. I cannot say the date of incident, that is the commission of murder. I am a priest at Renia Aurobindonagar, Hanuman Mandir and Shitala Mandir. Hanuman Mandir and Shitala. Thereafter, my lord will kindly come to. There is no road running east to west on the northern side of the PO, just 2 lines after that. Many people reside around the PO. House of Kedarnath Mishra is situated on the northern side of the PO. Then, my lord, the next page, the paragraph towards the last line, I did not lodge any missing diary. दे दीजिए
Your lordship like to take over. এটা কি জজ সাহেব দাও নি
না না একটা আগেরটা বানিয়েছিলাম এটা তো নয় দিয়ে দিই একটা কপি দিলাম
Well, just to give your lordship an overview of
This will take some time.
Yeah. But ultimately, my lord, all the witnesses, if your lordship kindly sees, 1 to 7 and 9 are the witnesses to the extrajudicial confession of Bablu Yadav.
Now, PW8 is the witness to the seizure and recovery of the skeleton. PW11 and 12 are the witnesses to the seizure of the choppers from the appellant and his son, Ranjit Sharma. And PW13 is the son of the deceased and the eyewitness who discloses the incident after Bablu Yadav makes the extrajudicial confession. And that means more than 2 years after the incident has taken place, has given a completely different version from that of the extrajudicial confession made by Bablu Yadav also. Now, the other witnesses who would be relevant, Malad, is the expert. They have not been able to, the blood sample was taken from the father of the deceased in order to do a DNA matching with the skeleton. Now, that could not be done. There could not be any matching at all because from the skeleton, it could not be extracted in an appropriate manner. So this in a nutshell is the case. I am in custody for 10 years and 6 months. Malad, would your lordship be inclined to hear this matter in full?
Yeah, we'll reject the bail.
Malad?
We are not inclined to give you bail.
Oh, very well. Then kindly here's this matter, because ultimately there was no identification of the skeleton as that of the deceased Madan Rai also.
If you can satisfy that the identification is through the wearing apparel.
No,
Wearing
Malad,
apparel
this
were
wearing
all
apparel, I'll take your lordship to the season list. It was not found from within the Bora. Or the
was found at the place where the the bones were recovered.
2 years later.
2 years. Malad, it was Malad. Your lordship will kindly see the season list. It's not found from that place. It is found from the PO.
Inside the yard.
Yes, from inside the yard. Malad, that, as your lordship has seen in the sketch map, it's quite a substantial piece of land.
No, board file, exhibit file.
Exhibit কত?
4. বলেছিলাম এটা বলেছিলাম যে বড় এরিয়া পাউন্ড এক্সিবিট এফআইআর এর পরে তারপরে এই যে
Kindly seize them.
At the time of digging, pant, shirt, and shoe were also.
That is being stated. It's not being mentioned by in the inquest report, nor by the magistrate, neither by the police nor by the learned magistrate who was present there at the time of recovery of the
What
bone.
about the evidence in court?
Evidence it?
At the time of the recovery of the bones itself, investigation report is 620, seizure list also.
If your lordship kindly sees the
Even if
inquest
there is-
report,
All right, we have followed, it's not there in inquest report. Will that take away the recovery at this spot as per seizure list? And what are the evidence of the investigating officer? How they were recovered? The evidence is oral evidence.
kindly sees PW 16 at page 55.
Inquest is after the recovery. Inquest.
No, he was present at the time of the recovery, my lord. Yes, kindly sees his version. The process, my lord, about 5 lines. The process has been started at 10:30 a.m. manually, but at about 2:30 on JCP, at about 3 p.m. some disintegrated bones were found in the bags.
uh, at the courtyard of one Sri Ganshagar Sarma. During the process, at that only 137 bones were found, including this. And in his cross-examination, the last line, your lordship kindly sees, I did not find any other wearing apparels or anything except skeleton by exhumation. Kindly sees page 58 thereafter of PW 17, the IO. I gave recusation to the, sorry, not 58. On 9 June, last paragraph. The IO says something, the executive magistrate says something else. On 9th of June 2014, I see some articles where from the skeleton was exhumed. These articles were found at the time of disinterment. But the executive magistrate does not say that. He is also present there.
Yeah, may have. He had concentrated on the recovery of the bone. The witnesses say that. Gautam Pandey says that.
Well, kindly considers, well, after 2 years, a person suddenly comes to a club. He thereafter makes an extrajudicial confession. The police purportedly is given a call. It is recorded in the GD as received from an unknown person. On that basis, they go to the place. Purportedly, Bablu Yadav shows them the place, which is the land of another person. From there, it is being recovered. The learned magistrate is there. The learned magistrate does not say that anything is being recovered except the skeleton. The skeleton is not being found to be that of Madan Rai by the expert. The expert's evidence is
PW 18.
PW 18.
Was in custody. Page 50.
His evidence is PW 18 ta kato. Page 70 is the evidence of the expert.
Has not identified. It's almost not identified.
देखो बोलो.
Page 47.
What was recovered from modern statement? Chopper.
Yes.
But there is no disclosure. There is
But no forensic done even to well, on and
How was he murdered?
Gunshot injury.
The prosecution's cases of gunshot injury, those choppers were purportedly utilized to dismember him and put him in the allegation. But so even recovery of that chopper is after 2 years from a place which is accessible to everyone. And there is no recording of any statement under section 27 so far as the petitioner is concerned. And there is no forensic examination done also to even connect it to be the weapon by which the chopping of the body was done. No gun has been recovered. There is no evidence that I was owner of a gun. Nothing. The son has not identified the wearing apparel, recovered apparels to be that of his father. Exhibit টা করেনি তো।27 of the sun আছে, ছেলের আছে তো। ছেলের একটা আছে, একটা তো আমি স্টেটমেন্ট দেখেছি। দাঁড়াও, আমার ছেলে একটা স্টেটমেন্ট আছে তো আমি আছে তো। No, there is exhibit 16. But it's of my son, perhaps, if subject to correction, madam. Ranjit. কোনো নেই। টাইম করো দেখালে ঘুরে বেড়াচ্ছে। 474. Page 494. Page 494. Isolated order. What do you mean? Fine. Seventeenth to May. How do I touch? Now kindly considers, well, the Bablu Yadav is the person who comes and gives the extrajudicial confession. He goes and points out the place where from it is being recovered. Well, he is not arrested. Kindly sees this is the order by which he is asked to be shown arrested on the 13th of June. The incident takes place on the 9th. The recovery takes, he gives his confession, takes the persons to the place of recovery, but he's not arrested. He is arrested in connection with another case on the 10th, and prayer is being made on the 13th for his production. Now he confesses that that I have killed, he has helped in disposal of the body. The police comes to the spot, it is recovered, everything is done except arresting him.
Hmm. Yes. Is what happened to the juvenile? Can you get a report? Bablu and Ranjit, what happened to the juveniles? Please get a report of that. Hmm? Get a report. What happened to the juveniles? What is the result of their enquiries?
ছেলেটা কি হয়েছে?
কালকে বা পরশু। তাই করো না। 7 days are Friday.
I think evidence is being in the court at Nattola.
Conviction not at Hmm? We are keeping this on 12th of March. And 12th of March কিছু আছে specifically? মনসুর মিদ্দে, আয়ুব আলী সর্দার, ইয়াসিন মিদ্দে। ঠিক আছে। That Mansur Midday and all. Mr. Dastur was there. Huh?
Yes, yes, Nausar Midday.
Nausar Midday. That is there. We are keeping this before that. Please get a report with regard to the not there are two juvenile persons. They are being tried separately. The fate of their trial. Fix for further hearing on
Abdu Yadav or Ranjit Sharma.
Other matters at 2 p.m. Yes, Mr. Mukherjee?
Yes, well, the next matter was.
How are you?
Not too well, my lord. Still, for 2 months, I've been asked not to walk much, my lord.
Appear online.
Right, great.
Next matter, what is there, Mr. Mukherjee?
Well, there's a report called for by your lordship pertaining to the trial court records. I'm in the applicant in CRAN 2.
All right. We will take it up at 2 p.m. State lawyer.
Grateful. Great. বন্ধ করে দে বন্ধ করে দে রানাকে ফোন করতে পারে রানা নম্বর আছে বন্ধ করবি
আপাতত বন্ধ করা থাকে আবার যখন হবে খুলে দেবো 76 নম্বর আইটেম হচ্ছে নেক্সট
না 76 এর এটাতে রানা আছে এটা কে ফোন করতে পারবে
হাওড়ের লোক
বুঝলাম
হাওড়ের লোক হাওড়ের লোক আসছে
না
Yes, but hey,
54, I'm there, 53. Sorry,
a report was called for. Report was called for. Mr. Mukherjee was saying that a report.
from our end.
Yeah. Then let's see the order.
You kindly gives me a reason. 50.
We'll see.
Before my lord, I am appearing on behalf of the appellant, my lord.
Yes, sir. Trial court records এসছে? The trial court records have come.
But 17th February order.
Yes.
And there's another appeal, my lord. There are lots of us noted it down.
Yes.
So, my lord, paper books have been given to us. So, fix up a date, my lord, after
Yes.
17th.
After
17th, my lord, 2 weeks, please.
we are keeping it in the monthly list of March.
April then.
It's April.
Yes.
So
Okay.
that once you are here,
Yes, my lord, I'll do it, my lord. I'll do it. I'm grateful, my lord.
the appeals, paper books have been prepared, appeal is ready for hearing. There are ample evidence connecting the appellant in the crime. Hence, we are not inclined to suspend the sentence. Parties are requested to collect the paper books, if not already done. Appeals will appear in the monthly list of February 2025
Well,
or
April.
April 2025 under the heading for hearing.
Grateful.
Our my lord, 54, we have not received any paper book, my lord.
Please take it. It's there.
Let's say CRM one, where bail incarnation is bail incarnation.
So far as 53 is concerned, my lord, the paper book is there. 54 is an appeal of 2020.
54 to key.
Connected, my lord.
Is it admitted?
Yes, it is admitted. They are
First,
preferred
so
and
54 will be heard along paper books be collected.
Let's say bail incarnation to appeal, we are filing cannabis one. That
we have rejected.
Reject.
Next.
Fifty-five.
55.
55. My lord, this is, my lord, was heard by your lordship on last Thursday, the two dying declarations. Your lordship wanted me to supply copy of the evidence to them. My lord, subject to correction, this was supposed to come on Thursday, my lord. Well, I have supplied them today. So
today you have supplied them?
Well, because Thursday, because
Thursday?
this is supposed to come up on Thursday.
Thursday. Fixed on Thursday.
Oblige.
For the appellant, may not, a conviction is under section 376 and may not POCSO Act, but the service is not complete yet.
May it please your lordships. My lord, on the last occasion, your lordship was pleased to ask for me the amendment of the 376 charge. But that came in 2008.
59 যত বাজে Next. We have perused the order dated 22/4/2022 in the granting anticipatory bail to opposite party. In the said order, the learned judge has considered the nature of injury on a non-vital part of the body and granted anticipatory bail. The order is a well-reasoned one and does not call for interference. Is a well-reasoned one. Full stop. Nothing is placed on record to show that the injury is a life-threatening one. Full stop. No interference is called for. Application dismissed. Next.
61, my lord, I am for the petition. And as per your lordship's earlier direction, I have served the copy upon the opposite
Lordship, I would
party.
request to make it not today
No, not today.
and led by Mr. Nandi, Lordship.
Let Nandi remain wherever he wants.
He said everything is with him, Your Lordship.
In this particular case, present petitioner is an octogenarian person, my lord, and the opposite party number 2 is a business partner. And she was threatened and they were tried to, my lord, take away the entire property of the petitioner, and that for that reason she lodged a complaint. And thereafter, the opposite party number 1 was granted anticipatory bail with the condition that she will meet the IO as and when required, my lord. Well, kindly come to the page, inner page 4, my lord. And after granting the anticipatory bail, she did not go to the IO, my lord, as per the IO. It is reflected from the, my lord. Come to the
order dated 19/1/2022.
Yes, my lord.
Granting anticipatory bail to opposite party
my lord.
number 2 has been challenged. In the say learned counsel contents that the opposite party, the learned judge failed to consider that opposite party had threatened the petitioner.
My lord, he's a
opposite party had prepared forged documents.
Yes.
In order to cause wrongful loss.
Your lordship, kindly come to the annexure P1. After the granting of anticipatory bail,
forged documents had prepared forged documents and forcibly entered into the petitioner's
shop room.
Full stop. We consider it is also contended that opposite party number 2 had not complied with the condition of bail and met the investigating officer. He is threatening witnesses.
Your lordship, kindly come to the page 6 of the charge sheet. It is very much clear from the IO's report.
We have considered the materials on record. Allegations in the incident case relate to possession of a shop room. Full stop. whether the opposite party number 2 forcibly gained entry therein may be request to be assessed in the course of trial. Full stop. Grant anticipatory bail granted to him cannot be said to be either perverse, cannot be said to be perverse on the score of non-cooperation with investigation. We note charge investigation is complete and charge sheet has been filed. Full stop. Custodial further interrogation is not necessary. Under allegation of threat also is bereft of vague and bereft of material particulars. Hence, we do not find any reason to interfere with the order in view. Next.
Well, this is the affidavit in reply and the affidavit of service reflecting the না দিসনি এই করে করে তুই রোজ দিন দেরি করাচ্ছিস Well, this small issue is whether a person after surrendering before the court of the learned magistrate and thereafter not pressing his bail application can thereafter go before the sessions court praying for anticipatory bail. And in those circumstances, whether the anticipatory bail can be sustained in law. And in fact, they had approached this honorable court, got it not pressed. Then they approached the learned sessions court, and the learned sessions court granted bail, anticipatory bail to them. Well, if I may only draw your lordship's attention to the order. যেটা ওরা সারেন্ডার করে দেয় এটা কি If your lordship kindly sees page 17 of the main application. Record is put up today by court's order. Petition filed on behalf of accused numbers 1 to 6 and praised for bail. Earlier charge sheet submitted this. The accused persons are not found on call. The surrender and bail petitions have been not pressed. Issue warrant of arrest against the accused. Well, thereafter they approach this honorable court. The order is at page 19. না এটা তো ফুল দুজনের ক্ষেত্রে
তিনজনের ক্ষেত্রে
Then did not press the application.
Yes. And thereafter they approached the learned sessions court. That order is the.
Yes, Mr. Amit.
Lord, what has happened in this case, Lord, the petitioner, Lord, here was prayed for Lord, cancellation of bail. The ex-public prosecutor, Lord, Lord, when he went to surrender before the court, Lord, there was a chaotic situation and we had to flee away from the justice court. But what has happened on the next time, Lord, we have lodged a complaint, Lord, to the Chief Justice. But since we are unable to appear before the court, Lord, we did not press the application.
How can you move a surrender petition without appearing before the court?
Lord, we went to surrender, but
you cannot go to surrender.
Lord,
the petition for surrender is filed after you physically appear in court.
Lord, we are not allowed to enter into the courtroom.
Then there cannot be an application for surrender at all.
That is the reason that we withdraw the application. We had to withdraw.
You cannot withdraw. Your understanding, if a person, a remand petition is filed, can you withdraw a remand petition? That means the surrender petition presupposes that you have been taken into the custody.
Lord, we were subject to kind sanction, Lord, we were not with the constructive custody of the court.
There it is impossible.
But only a put up application was allowed.
At
Only
that
a-
time, they
only
have
a-
to be
only a-
present,
no,
my
for
lord.
the purpose of put up application, Lord, your lordship
Huh?
kindly. No, for
Now
the-
put up application.
My lord, at the time of put up application, they have to be present. Then the learned lawyer takes charge of them. He's taken into custody at that point.
We were not into Lord, constructive custody of the court.
Mr. Ahmed, you cancel this bail, you appear afresh and pay for regular bail.
But in the meantime, there are subsequent events, Lord, which I need to bring to your lordship's court.
The only subsequent event which can save you is a withdrawal of the FIR.
But that has been stayed, Lord, in respect of other accused persons, Lord, because
Let it be stayed.
by the
Then
there are
it's bad
few-
luck, we will cancel the bail.
By the High Court, which is not challenged.
We'll cancel the bail. Let it be stayed. It's your headache to get it vacated.
May I just
It's your headache to get it vacated. We are making it very clear.
not on
There
my
is-
application.
How? In whosever application. Make an application in that petition.
Stays
Say, please modify the order so that I may appear and pray for regular bail.
Let's stays quasi
Wow.
petitioners, and they are not the petitioners there.
There is no difficulty.
May I just explain few things, Lord, subject
The
to
more you explain, we are giving him an escape route, Mr. Ahmed.
I leave it to
And if we are giving you an escape route by cancelling your bail, but saying that within 7 days you will surrender and pray for regular bail. And that regular bail shall be considered in accordance with law. But this order cannot be permitted to survive.
So far, Lord, the order granting can anticipatory bail.
Yes. Yes. You couldn't have been granted anticipatory after having escaped from the custody of the court. Irrespective of the fact that you ran away because you were to be beaten up by the public prosecutor and his men. You could have taken that to the court and said, please allow us to stay in your chamber.
We have immediately on the next day, Lord, we had
All
to-
next day stories are after consultation with lawyers. No.
Lord,
These rowdyisms will not be permitted.
I surrender before your lordship, Lord, that since, Lord, this is a place where, Lord, your lordship, Lord, can understand, Lord, that if a lawyer is a complainant, the right of representation of the litigants, Lord, is completely restricted. Lord, nobody is allowed to, Lord, appear. Now, Lord, in this case, particularly since, Lord, the
Then who
complaint,
filed your petition? Nobody is allowed to
they
appear.
have also escaped, not on that day.
Who
The
filed
moment they
your
came to know,
petition?
the moment they came to know that there is a agitation and there is a resolution from the bar also, so they have also fled away. So I was helpless, Lord, on that day. Lord, I leave it to your lordship. If your lordship, Lord, cancel it, Lord, I'll appear within 7 days.
Yes, yes.
But ultimately, Lord, my right of representation on that particular date was really restrained by, Lord, the lawyers of his association.
Let us see where
Lord,
where have you stated the
Lord, your lordship would kindly take,
Opposition
Lord, affidavit in opposition, Lord, we have
page 7?
affidavit in opposition paper, Lord.
ওর চিঠিটা কই?
Chief Justice
কোনটা? ওটা কবে
Then
লিখেছো?
on
17
the same day, Lord, when the warrant was issued, thereafter proclamation was also issued. But I had to approach, Lord, the Learned Sessions Court. The Learned Sessions Court stayed that. And then only, Lord, my application for
Page
anticipatory bail.
36 is there, but it does not contain any endorsement. কি আছে?
আমাদের affidavit in opposition টা
সেটা আবার কেমন করে লেখা আছে?
transfer হয়েছে কি 17
Give me a second. I have a counter case also, Lord, on that date. The Lord, kindly take, Lord.
এইটা মনে হয়
Counter case, justice के लिए complaint করছে।
Page 36 আছে।
That is page 36.
They are competent.
Whoa.
Where is the 16.3 order?
But 16.3 order is in page 17 of the main application. Well, the main application से गलत होता है.
Well, order dated Mr. Ganguly, Learned Senior Counsel, challenges order dated 1/7/2023, granting anticipatory bail to opposite parties on the ground that the said opposite parties had appeared before the on the ground that on 16/3/2023
Party, my lord.
opposite party on the ground that opposite party had appeared before the magistrate on 16/3/2023 and had escaped from the and thereafter had escaped from the court. As a result, warrant of arrest was issued. These facts were suppressed before the sessions judge, and the order granting pre-arrest bail was procured. He also contends the he also contends after an accused has surrendered before jurisdictional magistrate, he is arrested and taken into custody by the said magistrate. Thereafter, now, if he escapes from such custody, the prayer for pre-arrest bail, anticipatory bail is not maintainable. In response, Mr. Ahmed strongly refutes the aforesaid factual position. He submits his client is pitted against the former public prosecutor of the court due to as a result, his client was subjected to serious. His client was obstructed, had to face severe opposition and obstruction by the lawyer community, and on 16/3/2023 and on 16/3/2023 had to leave the court premises and was compelled to leave the court premises, and due to lawyer agitation, and on 16/3/2023 due to lawyer agitation was compelled to leave the court premises. Good stop. Thereafter, he applied for anticipatory bail, which was granted. Proceedings have been stayed in so and so. The allegations are patently absurd. The present case was instituted in retaliation to an earlier complaint lodged against the petitioner, and the allegations are patently absurd and inherently improbable. proceeding has been stayed where other accused in CRR
আমাদেরটা তো পরে, ওদেরটা পরে।
in CRR 4535 of 2022. Full stop. I have given anxious consideration to the rival submissions at the bar.
The ball.
Stop. Opposite party number 2 had lodged a criminal at the bar. Full stop. We have considered the materials on record. Going through the order sheet, we note opposite party had filed filed a surrender petition, going through the records of the case, we note on 16/3/2023, opposite party filed a surrendered before the magistrate and prayed for bail. Full stop. Thereafter, during hearing of the bail application, he was not present, and she was not present, and warrant of arrest came to be issued. When an accused appears before a magistrate, appears bracketed, colloquially referred to as surrender, bracket close, before the magistrate, he is taken into custody. He is arrested and taken into custody by the magistrate. Thereafter, his bail application is considered on merits. Full stop. Given this situation, after the accused has been arrested by magistrate and taken into custody, there is no scope of the said accused to pray for anticipatory bail. There is no scope for the accused to pray for anticipatory bail. His only remedy lies in seeking regular bail. Full stop. Mr. Ahmed argues that extraordinary situation prevailed in the court premises. The petitioner is the former public prosecutor of the court. Due to his overwhelming influence, there was agitation amongst the lawyers, and his client had to run away from the court to save his life. Full stop. Soon thereafter, she lodged a complaint with the Honorable the Chief Justice, annexed at page 36 of the opposition. We have gone through the complaint. In the complaint, it is alleged that similar incidents it is contended after in November, opposite party had gone to the court to pray for bail, but could not do so due to obstruction by members of local bar. However, obstruction on 16/3/2023, when she again appeared and appeared before the jurisdictional magistrate, and it is contended that the magistrate initially granted him bail against bail bond of rupees 1,000. But due to threat and intimidation by hundreds of lawyers, he ran away from the court and could not furnish bail bond. The aforesaid statements, either with regard to agitation in November. Now, the aforesaid statements are not supported by contemporaneous documents. No complaint was lodged. Now, with regard to the obstruction held out by the members of the local bar in November 2022, no contemporaneous complaint is placed on record. Even the narration with regard to the incident on 16/3/2023, that is, the opposite party after her surrender had been released on bail on executing bail bond of 1,000 is also not supported by the judicial order passed on that day. However, we are not unmindful of the pernicious and trade union-like pernicious practice which has gained ground in various local bars. A pernicious practice which has gained ground in various local bars to obstruct litigants whenever they are pitted against members of the bar. Full stop. This Mr. Ahmed rightly contends these unruly such unruly behavior from lawyers deny a litigant of his basic fundamental right to access to justice. Full stop. To access to justice. Full stop. It is now in this situation, now visualizing the situation from these compelling and extraordinary circumstances, we fully understand the compulsion which may have weighed with the opposite party which may have compelled the opposite party to leave the court premises after she had surrendered before the court and prior to the bail hearing. Full stop. But the legal consequence of her leaving leaving the court premises is also to be but the legal consequences of her surrender before magistrate, resulting in her arrest, and thereafter leaving the court premises without intimating, leaving the court premises, and thereafter leaving the court premises. লাইনটা কিভাবে বললাম যেন? But the legal consequences of her escape from the court premises prior to the bail hearing is undeniable. Once she had surrendered before the magistrate, and once she surrenders before the magistrate, she is to be deemed in once she appears before the magistrate, she is arrested by the by the court and is taken into custody. Thereafter, even if she leaves, even if she goes out of the custody due to compelling circumstances, it would not give justification. It would not give legal justification to entertain her prayer for bail. On the contrary, it was open to opposite party to assail the warrant of arrest before this court and seek necessary protection for appearance and regular bail. Full stop.
We have challenged it before the London Sessions Court.
So that is exactly, Mr. Ahmed. There is no scope for an anticipatory bail.
Only surrender.
Only surrender. There is no scope, and that's what we are saying. কি বলছি? And regular bail. There was no scope for her to turn the hands of the clock back. There was no scope for her after the judicial arrest to turn the hands of the clock back and seek pre-arrest bail and seek anticipatory bail. Full stop. In such view of the matter, we are of the opinion, moreover, these relevant facts were not placed before the learned judge while moreover, these relevant facts touching on the jurisdiction of the court to entertain the prayer for anticipatory bail had not been placed before the learned judge who allowed the prayer full stop. In such view of the matter, we are of the opinion the grant of anticipatory bail to the grant of anticipatory bail to opposite party is without jurisdiction and is liable to be set aside. Consequential orders are also set aside. Opposite party is directed to appear before the jurisdictional court and pray for regular bail within 7 days. It is made clear, she shall be rendered, District Legal Services, Secretary District Legal Services Authority shall ensure opposite party is rendered necessary legal shall ensure that opposite party is not hindered from access to justice and legal representation of her own choice. In the event any lawyer obstructs the course of administration of justice, the opposite party or the Secretary District Legal Services Authority shall place the matter before the Registrar General for initiation of appropriate contempt proceeding against the said lawyer. Full stop. Copy of this order while considering the bail prayer, the jurisdictional magistrate shall take into consideration the fact that there are case and counter case between the parties, investigation is complete and the proceedings have been stayed co-accused.
My lord, only after the recording of the submission of my learned friend, if your lordship only records that I have denied the allegations regarding any pressure being brought upon the opposite party number 2, and that is not reflected in the judicial order also.
Judicial order. Mr. Ganguly denies and disputes the allegations. Mr. Ganguly, as much as you are right in law, the circumstances which have been portrayed are very disturbing, and we will not allow this sort of
sometimes we are victims.
Everyone is a victim. We want persons not to be victims, and everyone to feel bold enough to make their own submission, whether palatable or unpalatable. This is the beauty of a adversarial system, that you can say whatever you like, even if it is not liked by the other party, right? So you have to give
provided one's voice is loud enough.
Yes, we have powers, Mr. Ganguly. Give me, if
Lord,
Mr.
your
Ganguly,
lordship
today,
keeps a
today I tell you-
CCTV
tell me.
in the court.
Huh?
Your lordship keeps a CCTV in the court of the learned CJM and the SCJM, and let it be monitored by this honorable court. Your lordship
The
can see.
problem of CCTVs are, yes, we can keep CCTVs. The identity of the victims, etc., are a problem.
That is so.
That is the problem. That is why we do not give CCTVs. But what we can do is we can direct the magistrates to. Yes, but the problem is the victim. The court has taken into consideration that the court has taken judicial notice of the disturbing state of affairs, which has taken judicial notice of the disturbing state of affairs, which, as per the disturbing state of affairs portrayed by opposite party in the court premises when she appeared before the jurisdictional magistrate to surrender and pray for regular bail. It is members of the local bar had obstructed her, and as a result she was compelled to escape from the premises, resulting in issuance of warrant of arrest. Good stuff. We take judicial notice of the fact that such acts of hooliganism, which is wholly inconsistent with the high ideals professed by the noble profession of law, and the noble profession of law has become a common practice in the law courts, particularly in the courts of the ACJMs, particularly in the magistrate courts where bail hearings take place. Full stop. The unruly and irresponsible behavior of members of bar, unruly behavior in court impedes, interferes with the smooth administration of justice and an objective adjudication in bail matters. In bail matters, full stop. In Swapnil Tripathi versus Swansea, the apex court held live streaming of proceedings. Apex court held live streaming of proceedings not only add transparency and access to judicial proceedings, access to courts, but act as filters to act as filters to lax and irresponsible behavior. Given this situation, we direct the Registrar General, we direct we direct that CCTV cameras be installed inside the courtroom of the Chief Judicial Magistrate, or inside the courtroom of every Chief Judicial Magistrate and additional Chief Judicial Magistrate, where where accused are remanded, where bail hearing and remand proceedings take place. Needless to mention, the recordings of the CCTV cameras shall be private and kept in the custody of the concerned court and not exhibited save and except direction of the said court or this court. Full stop. In order to ensure privacy, recordings shall be kept private and shall be preserved, kept private, shall be stored and preserved in the custody and not exhibited without the permission of this court, of the court concerned, or express order of the court concerned or this court. Full stop. In the event there is any allegation of misbehavior, unruly, irresponsible misbehavior by a member of the bar or any other person during the bail/remand hearing, the recordings of the CCTV camera, reference to this court for drawing up of contempt shall be made along with the recordings made and preserved in the court. Full stop. A copy of the order is sent to the Secretary, Judicial Department, Principal Secretary, Judicial Department, Government of West Bengal, Registrar General of this court for implementation. A report be placed before this court after 6 weeks.
Only my denial, my lord.
We have denied. We'll make those entries.
Deep.
But you are right. Your suggestion is right. We are not recording your suggestion.
No.
But so, Mr. Ganguly, your
Well, what can
please
we-
understand today your role is not only to represent a litigant,
No,
but
definitely.
to advise us as a senior advocate. And in that role, when you suggest this, it is well taken.
Well,
We were having a little bit of a we were having a little bit of a hesitancy as to whether we will bring in the cameras, but after Swapnil Tripathi, it is always possible, and in appropriate, and if it is the recordings are kept private and they are not live streamed, there is no question of any breach of privacy.
And in bail applications, generally the victims are not there.
Even if they are there, our purpose is to make the bail hearing where access to justice is most vital, responsive, objective, and free. It should not amount to browbeating of the judge or any meeting.
Also, if there are few contents are pending, that it may-
Correct. We will have to stop it. So this is one
Lord,
way.
give a- at least
Yes, you appeared for in the
two of the
Murshidabad cases,
as well as Chachal.
Chachol and Murshidabad.
You are pending.
We have
to
we
Lord
have
Justice.
we have issued rules of contempt, but I think before we issue rule of contempt, there should be some measures which are sort of sobering measures.
Yes.
These are sobering measures. They will engender sober behavior.
The difficulty is that sometimes this type of behavior becomes endemic. Everyone thinks that it can happen.
Mr.
बारी जावे तो चल गया
All right, in this matter, I'm appearing for the opposite party number 2, my lord.
কাগজ দিন না আমাকে
My lord, this petition is infactuous, my lord.
Look at his face. এটা একটু ভালো করে জি।
My lord, may I say something, please?
Yes, which matter?
The previous matter where Lordship passed an order about CCTV, your Lordship should include the district judge also, session judge.
Decision.
Yes, because 439, your
We are-
Lordship, at least in Alipur and Sealda, your Lordship has no idea.
We want to bring in some decorum inside.
Yes, well, that is, I have stopped going to Alipur, my lord. I have stopped going to Alipur
allow
because
that.
of the behavior of the lawyers there. I've got stopped going.
We cannot allow this.
That's why the session judge should also be included, well.
Alipur court is something which is very dear to my heart.
I know, my lord. Your father was a legend there. Your father was a legend there, my lord. It is very dear to your lordships.
Because of behavior.
Well, I had to leave the court. I couldn't argue. I had to leave the court.
We will consider that, Mr. Mukherjee will consider adding the court of the
District session judge.
district and sessions judge. Yes.
I'm grateful, my lord. I'm grateful.
We are more concerned about the remand hearings.
Yes. That's the one. That's the best thing your lordship has done today, my lord.
Fee for all fight. No.
Oh.
Really assisted by Mr. Ganguly, he gave the suggestion.
Yeah, I know, my lord. I'm grateful to him, my lord, for bringing this topic up, my lord.
I was in two minds. It was my brother, Justice Kant, who suggested, no, you go ahead and...
Hey, right, my lord. Absolutely. We're grateful to Justice Kant, my lord.
I am too jaded now to give these directions. So
Don't say that, my lord. Don't say that, my lord. Your lordship is reaching the peak of your lordship's career, my lord. Just the peak of your lordship's career.
None of them really have their impact. We've given witness registers so that they can be quick trial. Nothing happens. This is, sometimes it really makes one feel that it is a mockery that we are doing these directions. Nothing happens.
But this has to be complied with.
We want that. We want.
Yes, I'm grateful, man. I'm really grateful.
Yes, next matter. Yes.
My lord, this matter is, my lord, infractuous, my lord.
Infractuous.
Opposite party number 2 already acquitted from the case.
Already. Dismissed as infractuous.
I know.
Dismissed as infractuous. Apology. Petitioner submits, opposite party number 2 has been acquitted. Accordingly, application cancellation is dismissed as infractuous. Next.
But I'm the opposite party number 2, my lord. See, this is the affidavit in opposition. No, this is the opposition. We had
petition, the trade license was in the name of the husband of the present petitioner. That was, my lord, forged.
No cancellation necessary.
My lord, kindly appreciate, my lord, case started under section 467, 468, 471, 406, 420. My lord, the opposite party was the manager of the business. Who forged the signature.
Very bad.
Now, my lord, kindly comes to say the last.
Tell us, listen, the person is on bail for 2 years. Has he misused liberty?
My lord, we have lodged complaint, my lord.
All
Yes,
right.
I was threatened. At
Very
the same time, my lord, kindly see the last order. Order said that without going deep into the matter, my lord only said that dispute is in a civil election.
Correct. Mr. Chatterjee submit that the learned magistrate failed to appreciate that the opposite party has committed acts of forged documents. Learned judge failed to consider that the opposite party had forged documents and erroneously held that dispute is civil in nature. After grant of anticipatory bail, opposite party became emboldened and has been threatening witnesses. We have considered the materials on record. Anticipatory bail was granted in 2023. Stop. The no doubt 2023. No doubt, it is alleged in the FIR opposite party had forged documents in order to raise false claims. However, the claims were in relation to property, which, however, the claims related, however, there were rival claims of the parties, which may have prompted the learned judge to hold that the dispute is civil. Nonetheless, dispute is civil. We clarified that such observation is tentative and shall not have any bearing on the proceeding at the subsequent stages. Full stop. Be that as it may, the order, the bail order being passed in 2023, and as the allegations of threat are generic and not substantiated by cogent and cogent materials, we do not wish to cancel the bail, cancel bail granted to opposite party number 2. With these observation, application is dismissed.
Complaint regarding the post bail conduct. This may be added.
That is what we have said. They are general allegations. Next.
Man,
I am for the private acquisition.
I am for the all the person were declared to based on a prior that the incident was under section 306. So, Lordship, thereafter, chargeshit was set aside by this honorable court and handed over to CI.
Oh, not set aside.
Yes, chargeshit was set aside. Your Lordship, we explored the provision of 302 that whether that person was in a position to commit suicide by hanging itself. Lordship, the involvement of this accused person is required to be taken into consideration because they were.
Pradeep Ram.
And one more thing, Your Lordship. One more thing, Your Lordship. Piece of case has been registered against me. Silence my voice. I have also registered case under 195A. Lordship, until and unless they are taken into.
Sorry.
Kindly, Your Lordship.
It is for the investigating agency to decide whether they will be arrested or not. Petitioner contents. It is your son.
Yes, Your Lordship.
Petitioner contents. His son had gone missing. Subsequently, his gone missing. Subsequently, his body was found hanging. Present case was registered for abetment to suicide. Petitioner, opposite party was granted anticipatory bail. Subsequently, she filed a writ petition being WPA 23991 of 2023, and the Honorable Single Judge directed Deputy Superintendent of Police to supervise the investigation and find out materials under Section 302 IPC. Thereafter, 302 has been added.
No, my lord. No, my
lord. Thereafter, investigation has progressed, but
submitted, my lord. Father submitted, CID submitted charge sheet, my lord.
306.
Yes.
Acha. Thereafter, pursuant to further investigation, charge sheet has been filed, reiterating the same offense. In this backdrop, we do not find any reason to cancel the bail on the ground that a graver offense has been disclosed. It is finally, it is also argued that opposite party is regularly threatening the witnesses. A separate criminal case has been registered, being under Section 195 capital A of the Indian Penal Code. Opposite party, we are informed opposite party has been granted bail in the said case. Accordingly, we are not inclined to grant to cancel the bail on this score too. With it is open to the petitioner. Now, in the event the petitioner is aggrieved by filing of the supplementary charge sheet under section 306 IPC, it is open to the petitioner to agitate his grievances before appropriate forum, if not already done.
My lord, against the order of principal accused, my lord, granting bail, against that order, they have preferred another cancellation of bail. That has also been dismissed by the coordinate bench. That is CRM TV 111.
Very good.
Deep Lord.
Holding the case for the state. The Lordship had called for a report. Post bail conduct report, nothing.
Report is placed on record. Report does not disclose material substantiating the allegation of misuse of liberty. Anticipatory bail has been granted in 2023. Under such circumstances, we do not find any merit in the application, and the application is dismissed.
Anticipatory in 2022, Mala. 2022.
এই দুটো তো 23 complete. 67 তো 20 তো ও হয়ে গেছে তা ওঠাওনি কেন 22 রেগুলার বেঞ্চে তোমার বুঝি না ক্যান্সেল We have considered the materials on record. Opposite party number 2 was granted anticipatory bail. Perusal of the order shows that the judge had considered the case diary and contentions of the parties before granting pre-arrest bail. Order does not suffer from any illegality or perversity. With regard to the allegations of misuse of liberty, we note that the said allegations are generic in nature and not substantiated by material evidence. In such view of the matter, we are not inclined to cancel the anticipatory bail granted to opposite. Next.
Extremely grateful. পরে লিখে দিচ্ছি properly।
তোমার এখনো খাতা গুছিয়ে উঠতে পারোনি? Stress. 71.
We have the opposite party too. It was supposed to file reply. Consequent to filing of intervenor affidavit, they were supposed to file reply. Not yet supply the copy of the intervener's affidavit. No. It was directed to file a report on the intervener.
Please give copy. Adjourn 2 weeks.
Lordship, state was directed to file report on threats to intervener.
Report is placed on record.
And supply the copy of the report.
State report is placed on record. Matter will appear 2 weeks hence. Next, 72, same order.
সেদিনকে সে ছিল না একটাই দিয়েছিল।
Adjourn 2 weeks. Then, এই 24 কতগুলি ক্যান্সেলেশন আছে গো? In 2 weeks. 2 weeks. 75 and 6.
76, while I'm appearing. It's a suo motu rule was issued by our lordship while considering the bail application of a gentleman by the name of Sushil Kumar Bormon. Now he has been granted bail subsequently by this court.
All right.
And I mean bail, we are in bail since July 23.
Sushil Kumar, Mr. Mukherjee brings to our notice subsequent brings to our notice that a coordinate bench has enlarged who accused Sushil Kumar
Bormon
on regular bail. Good stuff. While rejecting his bail prayer, this is with regard to fake appointment.
Yes, of one Mr. Tiwari, my lord. His father was arrested and the son was arrested. Your lordship was pleased to grant bail to the father, who was the headmaster of that school, my lord.
While considering his bail prayer, this court had issued a rule calling upon the co-accused Purabi Vishwas De, the then District Inspector of Schools, Anjana Mojumdar, retired dealing clerk, and Nitya Kumar Maji, the then upper dealing clerk, to show cause why the bail granted to them be not cancelled. Full stop. Be not cancelled. Presently, Sushil Kumar Mondol,
Bourbon,
who was the then Assistant Inspector of School, has been granted bail.
23rd of December, 24.
Has been granted bail. Full stop. Given this situation, we are of the opinion cancellation of bail to other conspirators by a coordinate bench. Full stop. Given this situation, we are of the opinion cancellation of bail of the other conspirators would not serve any worthwhile purpose.
Grateful.
All six charge-sheeted accused granted bail.
चुप कर ना यूसुफ.
Would not serve any worthwhile purpose. Accordingly, we discharge the rule issued against them.
Grateful, my lord.
At 77, I am appearing on behalf of the petitioner. The last occasion,
I'm for the private opposite
he
party.
had filed a report.
I'm led by Mr. Sabir Ahmed, my lord, praying for an adjournment. He's on his legs in court number 26.
So,
I'm praying for.
that's an opportunity for you to open your mouth and not only seek adjournment. Yes.
I had sought for cancellation of bail mainly on the post-bail conduct. On the last occasion, state had filed a report which indicates that there indeed was threatening on behalf of the accused persons. And
where is the report?
The report on the last occasion, my lord,
it was placed on record.
was placed, my lord, on
All right.
my lord,
The
on
complainant-
10th of January.
Petitioner had challenged the order granting anticipatory bail on the ground that he had been threatened by opposite party number 2 and associates. Report
Both the private officers.
report is placed on record and report is placed on record. Report shows that investigation is complete. Petitioner and opposite party number 2 belong to members of the members of are related to one another. Though the after grant of bail, there was hot altercation. After grant of bail on so and so, there was hot altercation between them. This cannot be. This may have arisen because of various reasons, and cannot tantamount to misuse of liberty. Police had intervened and directed both the parties to maintain tranquility. Accordingly, we do not find any merit.
May I just indicate one thing? Both the complainant as well as the accused persons, they are residents within the same PS. So my evidence has not yet been recorded, Lordship.
No,
So
we won't do that.
Till my evidence.
Whatever you ask, Mr. Ganguly, we are not going to do that in a family dispute. You would achieve your purpose. What
I'm
you
ready.
won't get through the civil court, you will get through an order of condition of bail. No. Accordingly, we do not wish to interfere with the order granting ancillary bail to opposite party. Police is directed to maintain peace and tranquility in the area.
Deep pleasure. Great.
You got the outstanding.
He's already discharged from the charge sheet.
Opposite party number 2 has been discharged.
224.
224 have been discharged from the case. Application is dismissed as infructuous. This also should be there in the.
Lordship 79, I am praying for not today, Lordship.
This is the third time they are.
Lordship, reply needs to be filed. Petitioner is a.
Reply.
Lordship, last chance, Lordship. 1 week time, we will file the reply, Lordship. Lordship, last chance, Lordship.
These are wife and daughters of the petitioner.
Lordship, last chance, 1 week time, Lordship. Petitioner is a.
Opposite order dated 7/3/2024, granting bail to opposite party number
225.
225 has been assailed. Learned judge noted that the dispute between the parties are civil in nature
Lordship,
and
may
civil
I
proceedings are pending inter se. Full stop. Yes, what do you submit?
Lordship, the petitioners, the opposite parties, Lordship, have forgedly taken the sign of the petitioner and registered the deeds in their favor, Lordship. Lordship, in the last order, Lordship, called for a report from the state.
Whether the registered deeds are forged or not, are forged or a product of threat and coercion or not, may be assessed at the appropriate stage of the proceeding. Order impugned is a reasoned one and does not call for interference. Application.
Lordship, another submission, Lordship. During the pendency of this application, 2 complaints have been lodged before the local police station.
Allegations of threat are generic and not supported by material evidence. Rejected.
Report submitted by the state to be kept on.
Copy of the report be handed over, Lordship.
Peruse report of the state is placed on record. Next.
But I am for the petitioner.
Yes.
But this is the opposition. We have to file the opposition and this is the affidavit on behalf of the landed advocate.
Affidavits during hearing of the bail application. Bail or anticipatory bail application?
Anticipatory bail application.
During hearing of the anticipatory bail, but this was by Basak, na? The rule was issued by a coordinate bench presided by Justice Devanshu Basak. Accordingly, the matter is released and placed before the Honorable the Chief Justice for assignment before the said bench for consideration of the matter, for consideration of assignment of the case before the same bench. Justice Boshak speech. Next.
Lordship, third application for anticipatory bail was
This is my opposition, my lord.
allowed, first rejected on July 27, 2023 on merit. Then on September 18, 2023, it was not pressed. Thereafter, Lordship, on 2nd of November 2023, it was allowed as the charge sheet was submitted.
My lord, one thing, my lord, since 2023, my lord, there is no adverse report, my lord. Another thing is that, my lord, when it comes to page, my lord,
What is
13.
the stage of the proceeding?
Lordship, only charge sheet submitted, thereafter no development, subject to correction. But this third application was allowed.
In the order of my reflections that, my lord, prior to that, my lord, my application was
But
rejected.
this was disclosed.
My lord.
No, it was.
Yeah, it was disclosed.
But only change was.
Petitioner submits that the order granting the prayer for anticipatory bail of opposite parties was rejected earlier on merits on 2 occasions. And in the third attempt, they were granted anticipatory bail on the specious plea that investigation is complete. Though we are convinced that the reason given by the judge that conclusion of investigation is a justifiable mitigating circumstance to entertain the subsequent prayer for pre-arrest bail, we note that opposite parties are on bail for more than 2 years and have not misused their liberty.
There is a report to that effect.
Report submitted by the state also corroborates this fact. Under such circumstances, we do not consider it fit to cancel their bail. Full stop. Application is dismissed. Dismissed.
Yes, my lord, I am for the petition. My lord, the prayer for cancellation only 2 grounds. The learned judge at the time of granting bail did not consider the injury report, but on the date of incident.
Let us see.
And the
And
post bail
second round.
and the fourth post bail conduct is also there.
Achha. We
My lord, I have no instruction till date of the post bail conduct of the accused. My lord, let a report be called for.
learned lawyer challenges the order granting anticipatory bail on the ground that learned judge had not considered the injury report and that the opposite party, after grant of bail, is threatening witnesses. On the first ground is unfounded. The first ground is unfounded. Perusal of the order shows the learned judge looked into the case diary, including the injury report, and came to a finding that custodial interrogation is not essential. On the second issue, with regard to misuse of liberty, we find that the allegation of misuse of liberty is extremely vague and bereft of material particulars. Hence, we do not wish to interfere with the order granting. Next.
84 and 85, my lord, same police station, arising out of same police station, different criminal miscase.
Rejected, rejected.
My lord, 17 September. Lordship, kindly have a look in the coordinate bench order.
Rejected.
My lord, rejected, my lord, on that score, my lord. Kindly have a look into the order dated 17 September.
We have considered the order granting anticipatory
But
bail.
that order not comply, my lord.
What order is not?
17 September.
There is no
20
order of 17th September.
Yes, my lord.
What? 1/4/2024 order challenge.
No, this court order passed.
There is no this court order. For the time being, we
The order dated 17th of
ठीक है,
September.
दाঁড়াও না,
passed.
দেখছি।
ছিল আমাকে
ফাইলে with regard to documents. Yes,
My report says they have given.
they have given. Report is placed on record. Relevant documents have been handed over by the handed over to the investigating agency or petitioner, opposite party. Under such, we have also perused the order granting anticipatory bail. Order shows that the dispute arose between the promoter of the property and
the
owner with regard to compliance of the terms of the development with regard to breach of terms of development agreement. Taking note of these facts, bail was granted. We do not find any scope for interference in this order.
Next one is similar.
Next, same order.
Gratefully, your lord.
Grateful.
I
86. Nosiruddin. এর জন্য নসিরুদ্দিন এলো। We have considered the abaments in the application for cancellation of bail. Prayer has been made on the ground that opposite party number 2 opposite party number 2 family members of the petitioner were told to withdraw the application, failing which they will face dire consequence. The bold statement is bereft of material particulars with regard to date and time when such threat was held out. Hence, we do not find any reason to interfere with the order. To cancel the order. Granting it. Same order. Same order. Hadda 88 होता है. Same order. Same order. We will go up to 90. Other matters not to take.
89, my lord. I'm
on the opposite party.
Opposite party. On the service card direction,
Stated. 98.
তোমার অ্যান্টিসিপেটরি চাপ ক্যান্সেলেশনের চাপ কমে গেল।
Oh, well, on post bail conducts.
Where is your post bail?
Well, page 23 onwards.
Page 23. Nothing.
My lord, there is currently, my lord, there in January, my lord, an FIR has been again registered.
my lord. On
My lord, this is a connection with anticipatory bail of the father-in-law and the mother-in-law, who was not even residing at the place of occurrence, my lord.
All right. Opposite party petitioner has assailed order dated 14/6/2024, whereby learned judge has granted anticipatory bail to the opposite party number 2 and 3, the parents-in-law. Full stop. We learned lawyer contends that petitioners have opposite party number 2 and 3 have held out threats after on the ground that they have কি বললাম যেন? Lawyer contends that opposite party number 2 and 3 misused their liberty and held out threats. However, the documents annexed to the petition do not specifically refer to role of opposite party number 2 and 3, that is the in-laws, in sending in making any threat to the petitioner. Hence, we do not find any reason to cancel the order granted to them. Next, Nasima Banu.
Great.
Malad 90, Malad, and for the petition.
Yes.
Malad, it is a Malad 302 case, Malad, 7 petitioners.
Yes.
Out of Malad, 3 has been rejected on the ground that they are the Malad male and the 4, yes, Malad. And 4 Malad female, they are allowed only on the ground that they are female. Whereas Malad, the observation of the court, Lordship kindly see that the involvement of the petitioners cannot be ruled out. Lordship kindly see the order, Malad.
Bring the case date.
Malad, order dated 20th Malad May 2024.
We have considered the petitioner has challenged order granting anticipatory bail to opposite party numbers blank to blank. Full stop. He contends that the learned judge failed to consider the gravity of the offense and granted bail to the said respondents opposite parties on the ground that they were female. We have perused the order granting anticipatory bail. Anticipatory bail to the said opposite parties. The learned judge noted that the victim had suffered head injury due to hurling of bricks. Accordingly, he declined to grant anticipatory bail to the male members who were more male members who were more probable to have played a predominant role in the assault. Noting this fact, he granted anticipatory bail to the women folk of the family. Full stop. We do not find any perversity or perversity in the distinction so made where the role of the party, where the role of distinction so made with regard to the predominant participation of the main folk in the assault. Full stop. Hence, we choose not to interfere with the order granted to the authorities.